Welcome back. Last time we discussed the philosophy of the divine law, and in this segment we'll take a closer look at the sources and methodology of Islamic law. Where does the Sharia come from? First of all, the Sharia comes from the will of God at the highest level. Secondly, all of the Sharia is contained, at least in principle, in the Quran. Now, every single word of that statement is made very, very carefully. I said all of the Sharia, and then I said in principle is contained in the Quran. So you might find actual injunctions of the Sharia that are not in the text of the Quran. Some of the Sharia is contained in detail in the Quran, like how you divide your inheritance among your children. Some of it is not contained in detail, but in principle. But there's no part of the Sharia whose principle is to be found outside of the Quran. And thirdly, the Hadith and the Sunnah of the Prophet are, after the Quran, the most important source for the Sharia. All schools of Islamic law, although they differ in some respects, agree on these points. If the Quran and Sunnah and Hadith contain the whole of the Sharia in principle and often in detail, it is still necessary to apply these principles in new situations as they arise. Although in his lifetime the Prophet provided numerous precedents through his words and deeds for guiding the work of jurists of later generations, it was impossible to provide comprehensive guidance for every conceivable circumstance of life, if for no other reason than the fact that many of the ethical dilemmas encountered later in history by Muslims simply did not exist at the time of the Prophet. Thus, a methodology of jurisprudence developed over the centuries that have now crystallized into several major schools of Islamic jurisprudence or fiqh. As we discussed earlier, law taken directly from the Quran and Hadith is referred to as the Sharia, whereas the word fiqh describes derived law, that which comes from an integral understanding of the Quran, Hadith, and rulings of Islamic jurists over the centuries since the life of the Prophet. A methodology of jurisprudence and a variety of approaches developed over the centuries that have now crystallized into several major schools or madhahib of Islamic jurisprudence or fiqh. All schools of Islamic law agree about the basic sources of the law in the Quran and Hadith and Sunnah, but they differ as to their application in new situations. The process for arriving at an all things considered ethical judgment is called ijtihad, a process that provides a powerful means of understanding the nature of fiqh. It's important to recall that any ethical judgment is not just one judgment among many to be weighed against economic, political, and other judgments in deciding how, all things considered, to act. It is itself an all things considered judgment, which takes all of these other factors into account. Jurists qualified to carry out ijtihad must therefore combine several distinct skills to arrive at proper rulings. First, they must possess knowledge of both the Islamic legal and intellectual heritage. Second, they must have knowledge of the situation on the ground. And third, they must know how to integrate this knowledge to arrive at wise rulings. To arrive at legal rulings, various principles can be employed. Ijma' means the consensus of legal scholars through ijtihad. And for the Sunni world, which is the vast majority of Muslims at about 86% of the Islamic world, it's based on a hadith of the Prophet that my community shall never agree upon error. And therefore, when there is a legal matter upon which the legal scholars agree, it can become a source of the Sharia. But, and this is a very big but, provided that ijma' does not oppose the Sunnah and the Quran. There is a hierarchy here to which I shall return in a moment. Another tool for ijtihad is qiyas, analogical reasoning. The classic example of this is that of alcohol. Wine is forbidden in the Quran, and therefore so are beer and Scotch whiskey. Because of qiyas, no one can say, but when the Quran says that you should not drink wine, that meant wine that is made from dates, which was the type of wine at the time. But this wine is made from French grapes. And so God didn't mean this wine. And so that sort of thing would be eliminated by qiyas. Maslaha, that is, the common good or public interest, can also be considered in making ijtihad, according to some schools. There are many other potential indicators in ijtihad, but different schools of law have different approaches, to which we shall return next segment. But what I want to emphasize here is that there is a strict hierarchy of sources in Islamic law. First of all, anything that is mentioned in the Quran explicitly, although this could never really happen, but if you could find the Sunnah of the Prophet which contradicts that, the Quran wins out. That has never occurred, but in principle, this would be the result. No part of the Sunnah could ever contradict the Quran. No ijma' could ever contradict these two. For example, you could not say that the people of Pakistan would all get together and would decide, like President Habib Bourguiba did in Tunisia, that you should break your fast because the factories would be more productive. You probably don't know this story, but many years ago, Habib Bourguiba, then the president of Tunisia, who was completely French in his thinking, went before the Tunisian television in the middle of Ramadan. He took a glass of water and drank it, and said that to help the Tunisian economy, it's better for the Tunisians not to fast. And of course, it caused a wave of unbelievable excitement and opposition in Tunisia and elsewhere. And a couple of months down the road, you had the worst flood in Tunisian history, and all of the agricultural produce was ruined. That was God's answer to his glass of water. That means the people of Tunisia, the people of Pakistan, do not have the power through ijma' to undo the Quran and the Sunnah. This is the great difference. The same principle applies to other indicators in making all things considered ethical judgments or ijtihad. This hierarchy has important implications for Muslims living in the West, who are required to respect the laws of the land so long as they do not contradict Islamic laws and practices. For example, if the speed limit is 55 miles per hour on the highway, I'm required as a Muslim to obey the speed limit. But if there were some strange law passed that required me to eat a ham sandwich, I wouldn't be required to obey that, and would, in fact, have to disobey it. Although such an example is far-fetched, there are cases that are not so far-fetched that can pose a challenge to Jewish, Christian, and other beliefs in addition to Islamic beliefs, which we'll consider in our discussion board. That concludes our discussion of the sources of Islamic law, and next time we'll turn to the major schools of Islamic law.